Your Honor, I believe she's been previously sworn. May I proceed?
Scott, you understand you're still on the road?
Yes, sir. Yes, Your Honor.
Tonya, you have a statement you want to read to the judge. Would you do that now?
I committed a terrible crime. I embezzled a large amount of money and let greed take over my life. I've caused great pain to Innovate Mississippi, its employees, my family, and my friends. I'm deeply sorry for all the pain and suffering I've caused. I was Chief Financial Officer for Innovate Mississippi for several years in a position of trust. I abused that trust. There's not a day that goes by that the agony and pain of what I've done does not weigh on me. I will spend the rest of my life with the terrible decisions I've made and the consequences and pain that they caused others. I've caused a tremendous financial burden for Innovate Mississippi, my husband, my children, and my parents. I take full responsibility for what I've done, and I want and I need to pay Innovate Mississippi the restitution that has been ordered for me to pay. I've been fortunate enough to find an employer that knows about my crime and hire me anyway. I've been employed with Jana McDonald in USAC Car and Truck Rental for the past 3 years. And Jana said, when I first came in the interview, she didn't want to hire me. But she told me that God told her to, and that she would to be on this journey with me. And she's been there every step. And she's not only my employee, but she's my friend and has become a mentor to me. I don't want to lose my job. I love my job. And I need it in order to pay restitution back to Innovate Mississippi. I realize that many feel that the sentence I was given in federal court was lenient based on the large sum of money that I embezzled. I realize that there are consequences for my actions and that paying the restitution does not take away from the crime that I've committed. I'm asking for compassion and leniency in your decision. I do not want my family to suffer a second time for my crime. I admitted responsibility and admitted my embezzlement the moment I was brought in question 4 years ago. I immediately began seeing a counselor, Chris Webb, at the Center for Hope and Healing, and continued seeing him throughout this process. My youngest daughter, Victoria, was also seeing a counselor for the anxiety she has dealt with over this situation in my poor decision making. I've been trying to deal with the decisions I made, why I made them, and the consequences and pain I've caused others from them. I'm asking for compassion for my 2 daughters, Caitlin and Victoria, as well. Every time I look at them, I see the pain that I've caused. I'm begging you for mercy for not only me, but for them, so that I can continue to be their mom. For this process, I've met many people during my federal and state incarceration. I realize that a lot of convicted felons don't have the support system of family and friends that I have. Many have their families turn their back on them and desert them, and I will never take for granted my family and my friends and the opportunities that I've been given. I'm trying to make the most of the second chance that I've been given. I'm begging you to not see the criminal standing before you, but the person that I am today. I will never do anything like this again, and I'm begging you, this court, for mercy.
Your Honor, at this time, our next witness is Tony Jeff, the Executive Director of Innovate Mississippi. In this case, he will be stated by Grant Parner.
name, spelling your name for the board.
Tony Jeff, Tonyjeff.
And sir, where do you work?
I'm the president and CEO of Innovate Mississippi.
And Innovate Mississippi is the victim in this matter, correct?
Yes.
Have you been authorized to speak on behalf of Innovate Mississippi today?
Yes, our board of directors has met and discussed this at length and is unanimous in having me speak here today.
And what does Innovate Mississippi want to convey to this court about this sentencing?
So at this point, Your Honor, the victim Innovate Mississippi is most interested in the financial restitution. Our financial situation has been precarious since the time of this. It is not quite precarious, but still, the financial need is still significant for us, and so our primary, really only consideration is the financial restitution through whatever means that's available.
We have no further questions.
Your Honor, brief comments to conclude our presentation. Your Honor, I do not envy you in the situation that you are in every day. Not just this day, but passing sentence has to be the most difficult thing that you do in your position. I've always been confounded by this idea that we have to, or as we're commanded to, through the prophet Micah in 6:8, justice should be done, but we also should love mercy. Oftentimes those are different things, or they at least appear to be. As we stand here today, there is a path forward that achieves both goals and that achieves what our legislature and I believe our public wants us to do in these situations and what they expect from our criminal justice system. We have a victim here that wants the restitution. No one is trying to minimize Ms. Klauser's crimes. Ms. Klauser herself has taken responsibility from the moment she was confronted 4 years ago. She has worked hard to pay restitution. She can continue to pay that restitution if she is able to do so outside the confines of a prison cell. That does not mean that this court has to go easy on Mrs. Klauser, and I'm not going to ask you to. Your Honor, there are 2 counts to which she has pled guilty, both of which carry a maximum of 10 years in the penitentiary. There are several statutes at play here as I outlined in the sentencing memo. This court has the opportunity to suspend all or part of any sentence that it imposes in each count. You can run them concurrent, you can run them consecutively. There is another provision of our statutes that allows for house arrest. House arrest can only be allocated in 5-year chunks. You can do no more than 5 years house arrest until on each conviction. So, Your Honor, I would present to the court that it's possible, it might be a very good sentence indeed, to consider 5 years of house arrest on each and run them consecutively to one another for a total of 10 years house arrest. That is in no way a light sentence and cannot be discounted by anyone. That's a decade of home confinement, wearing an ankle monitor for the next 10 years of her life. That would allow us the opportunity, Your Honor, to have her pay restitution. And I would offer up that the federal sentence was especially deficient in one regard, and that was that they lessened the amount of restitution she had to pay starting in December of this year. From December of 2015 through December of 2017, she was to pay 100% of her salary. Going forward, though, from 2017 until the entire restitution amount was paid in full, she was to pay 50%. Your Honor, if she were to pay 100% of her salary at $43,000 a year, granted that's the gross and not the net, that it begins to get us to the roughly $500,000 mark that is remaining. We have a victim that is asking for this. Your Honor, I think it is a substantial sentence, and I think that that would be a good way to meet all of the ends of our criminal justice system here today, and I ask that you would post that sentence.
Thank you. Mr. Gibbons.
Yes, sir, Judge. Two things I'd like the court to consider in imposing sentence, and I will be extremely brief. One, we've heard a great deal of testimony this morning about the effect that the sentence imposed would have upon the family and the employer of the defendant. I would say that this is not unique to the situation, that in any sentence that the court hands down, the court routinely has to balance what a punishment should be and routinely takes into consideration any impact that it may have, not just on this defendant, but on any defendant's family. And if incarceration is imposed in any case, Your Honor, I would say that in any case in which incarceration is ordered by the court, it negatively impacts each and every defendant who would appear before this court. The other thing, Your Honor, I'd like this court to consider is this was a continuing pattern of criminal behavior. That this embezzlement was ongoing for a period of 3 years. This was not a one-time isolated event where someone had a brief moral breakdown and chose to take something. But as been agreed to in the defendant's memorandum, it is said that the defendant was engaged in years-long schemes of using company money for her personal gain. So I would ask the court to consider, Your Honor, that this was a continuing criminal behavior that went on for a substantial period of time. The state would allege it occurred over a 3-year period. And then finally, Judge, just for the court's reference, I'd like the court to know that the dollar amount lost in this case, this is the second largest embezzlement case in Madison County, at least since I've been in the DA's office, that has been prosecuted. So for the last decade, we have prosecuted only one case where the dollar amount would have been larger than this case. In the memorandum prepared by the defense, the memorandum states that the defendant has agreed that Innovate Mississippi was deprived or money was taken in the amount of $598,143.38. If the court were to consider the restitution that has been paid to date to Innovate Mississippi, the loss still exceeds over $500,000. Those dollar figures are staggering, Your Honor. So I would ask the court to consider those factors as the court imposes sentences in this case.
Anything else?
Well, Your Honor, I would just point out that, especially with regard to the second point made by Mr. Guest, no one has denied responsibility in this at any stage. And again, Your Honor, I would remind the court that the victim does desire to have the restitution in this matter.
All right, thank you.
And that would be impossible with incarceration.
All right, Mr. Ackerberger. All right, Ms. Klauser, and I've said this before, I'll say it again for the record, that you did enter a plea of guilty on June 12th of this year to 2 counts of false pretenses. I have reviewed the pre-sentence investigation. I've also reviewed the letters that were submitted to me this morning by your attorney. There were 13 different letters. It took me a little bit of time to review those, but I felt, as I said before, compelled to read those and make them part of the record here today. Several of those letters were penned by some of the supporters that you had here today. Some of these supporters I have I've known, I have great respect for, as a matter of fact. After reading these letters and hearing what I've heard today, there's a common theme that keeps appearing, and it's an extremely personal thing. Everybody here knows you personally. Everybody's experienced positive things from you, and I can tell you, it's not uncommon to receive letters like this, but it's not common to have this volume. Monday we had a busy day where we had over 30 people in here, like you, not like I'm talking about it, you're standing where you're standing, and did not have a crowd as big as this probably all day. Certainly nobody as big as this in support of these individuals that were standing here. It's hard not to take that into consideration. It's just the way it is. There's been a plea it appears, and I know from Mr. Eichenberger there has been, and I see in the letters, for you to remain or for you to be out of custody for family and friends and quite frankly for the sake of restitution itself. And I don't think that there's any doubt from hearing you and from hearing your friends, and I'm going to call them all your friends and family, that that you've accepted this responsibility, that you are remorseful. I believe that. I don't think there's any question about it. You know, but there's a lot of other things that I have to consider, and you know that. I mean, when you were in here before, we had this conversation briefly, and there's just some things that I do have to consider, and I consider them in every case, and every case is different. It's my understanding that Innovative Mississippi is a nonprofit corporation that's funded, am I to understand, exclusively from federal and state monies, or is there private monies in it also? Is that correct?
Your Honor, I don't want to get into the funding of Innovate.
I think I'd actually read that, I think, in your memorandum.
I think it is primarily that, but I don't know exclusively.
Okay. Which, of course, is, we know where those federal and state monies come from.
That's right, Your Honor.
You know, the fact that you took, which is stated in your attorney's memorandum, that you took over $500,000 and close to $600,000, and this was over a period of several years, and I don't know at what point it stopped, but there was, it appears that it stopped about the time that you got caught. Money's a powerful thing. There's no doubt about it. I mean, we're seeing that nationally. We're seeing that in this state. Money can change people. And there's been a good bit of spiritual quotations here, but you know the love of money. Well, I've seen it too much, and it can change people. But like I said, I do believe that you are remorseful. I will say that, and I do think that you have accepted responsibility. You've asked me, and several people have asked me, to be compassionate and be merciful. I would hope that everybody knows that I try to do that every day. My heart goes out to you, goes out to the victims. And when I say the victims, I'm not talking about just Innovative Mississippi, I'm talking about everybody that's talked today. Everybody here's a victim. Everybody has spoken this. I don't think there's any doubt about it, because they're speaking from their heart, and it's hurting them tremendously. I've said this before, it's not me giving you anything. Quite frankly, you've earned it, and you know it. And I'm not telling you anything that you don't know. But today, like Mr. Eichenberger said, it's my job to make that decision. And I can tell you, there's a lot of times I don't like making the decision, but I know it's what I have to do. I look into my heart every day. Every day. Like I said, these are all case by case. This is never a cookie cutter situation in here, but after taking everything into consideration as to false pretenses, which is actually count 2 in the indictment. Count 1 was dismissed. Count 2, false pretenses, is the order of this court that you serve 10 years in custody of Mississippi Department of Corrections, be released after you serve 4, and be placed on a post-release supervision for 4 years, for 5 years, on the court's standard order of supervision. Count 3, false pretenses, be the order of the court that you serve 10 years in custody of Mississippi Department of Corrections, be released after you serve 4, placed on post-release supervision for 5 years. Specific conditions will include a restitution amount that will remain open. At this point, I don't know the exact amount. don't know, without knowing the amount, I'm not sure about how we would set that payment plan up, so it's going to remain open for 30 days. And I'll ask the district attorney's office and your office to give me a figure on that. Court costs and assessments of $879 will be added to that, and we will come up with a total amount that will have to be paid and how that will be paid. These sentences are going to run concurrent. You realize from your lawyer that you have a 10-year maximum potential on each one of these. So 6 years of that is effectively suspended. You understand that? I hope when I walk off here that I feel like I've done the right thing. It's one of those things that I carry with me, like I said, every day. And I wish you the best, and I wish the victims the best. All right. Anything else?
There you go.
Anything from the state?
No, no, you.
Thank you.
Back to that one for quick.
Oh,